Hi again, everyone. This is Martin Boyle, and this is the second lecture that I'll be putting up today for session one, and that is the UK Constitution. Of course, this begs the question: do we actually have a constitution? And that's what we'll be looking at today. So I want to start with just present you with two dilemmas. These are two very recent court cases. In the first one, a mother was accused and convicted of abusing and killing her daughter, Star Hobson. This is a very tragic and upsetting case, and the Attorney General, after the fact, after the actual sentencing, intervened, saying that she was minded to increase the prison sentence on Star Hobson's mother. In the second case, a similar thing happened. Obviously not as tragic and upsetting, but this was a case where a statue of Edward Colston, a slave trader from the 18th century, was toppled in Bristol by Black Lives Matter protesters, and they were acquitted of any crime. They were found not guilty of the crime that they had, the offence that they'd been accused of. Again, the Attorney General intervened and said that she was going to look at this case and perhaps increase the sentence, or go to retrial to try to get a conviction. Now, of course, this raises a puzzle. In what way? It raises a constitutional puzzle. How are the judiciary, the legislature, and the executive separated? How are their powers separated in a liberal democracy? In other words, is the Attorney General actually allowed to do this constitutionally? So that's something to consider. What is a constitution? Well, a dictionary definition might be that it's an authoritative set of laws, rules, and practices specifying how a state is to be governed and the relationship between the state and the individual, or a framework for the political system establishing the main institutions of government, outlining their powers and the relationship between them. Here are some modern constitutions. I think obviously the most famous one in the world, I think, is the US Constitution, isn't it? 1787. Interestingly, if we think back to the previous lecture, this is around the time of the French Revolution, isn't it? The US Constitution was heavily influenced by a book called The Rights of Man that was written by Thomas Paine. Obviously this was printed later, but his writings and his ideas and thoughts came a lot earlier as well, and so they went in tandem. So a constitution is a written fundamental law. It reflects the popular will, and that's quite important. Popular meaning of the people, not that everybody likes it, but that it is, the combined, constituted will of the population of a country. And it's to do with governing institutions. It's to do with the powers of the executive, so presidents, prime ministers, and how they operate through government departments in order to enact policy. The legislature, Parliament, In other words, Congress, the Senate, the House of Lords, the House of Commons, and so on and so forth, and the judiciary. What's the relationship between them? Are their powers separate? This takes us back to the previous slide and the actions of the UK Attorney General. And a constitution identifies citizens' rights to protect the citizen against the state, which is quite interesting. In a liberal democracy, citizens have rights. The governing power is there only with the permission of the citizens. And so citizens must have rights, and these rights must be identified. And of course, in a constitution, there are provisions for amendments. So in the US Constitution, there are numerous amendments to the original document. The UK Constitution, again, this may be a contradiction in terms, but let's see whether it's actually written or not. Mr. Podsnap in Our Mutual Friend by Charles Dickens says this: "We Englishmen are very proud of our Constitution. It was bestowed upon us by Providence. No other country is so favoured as this country." So who wouldn't want to be an Englishman? Everybody wants to be an Englishman because we have the greatest constitution and we have more rights than anyone else, and we are exceptionally favoured. Is this actually true? Is there a constitution? Well, Edmund Burke, the 18th century philosopher, and Hegel, the German philosopher, talk about a constitution reflecting not so much political institutions as a national spirit. So it's this idea that it's not necessarily something that needs to be formalized and written down, but it's something that's understood. It's to do with the nation rather than the state. It's to do with the people and how they feel. So feelings over material facts. It's about a distinct British political culture, and Walter Bagehot in the English Constitution makes a distinction between the dignified and the efficient parts of the Constitution. So whereas the efficient parts would be to do with institutions, the dignified parts would be to do with the national spirit. So the efficient parts would be, for example, the laws, the rules, how the government actually works, the nuts and bolts of that. The dignified parts, the higher level parts, the more philosophical parts, the more spiritual parts. So many constitutions talk about God. They talk about the will of the nation, the destiny of the nation, and so on and so forth. And these are the dignified parts of the Constitution. Is it unwritten? Is the British Constitution unwritten? And if it is unwritten, then why? Well, it's not completely unwritten. After the 18th century, popular nationalist revolutions prompted what we call social contracts. Jean-Jacques Rousseau in France at the end of the 18th century talked about a social contract between the state and the nation, or the state and the people. They have rights and duties. So rights and responsibilities. The state has certain responsibilities to protect the people, and the people have certain duties towards the state, and that is to be loyal, primarily to be loyal to the state. And this is codified in a certain way. So the social contract can be codified in the form of a constitution. Obviously, that doesn't exist in one single document in the UK. We also need to look at English political revolutions in the 17th century. So here we're talking about the Civil War primarily, and after that, the Glorious Revolution. The Bill of Rights, which came after the Glorious Revolution, kind of codified a certain form of social contract, but it wasn't a full document that represents a constitution. Written constitutions are always interpreted. You always need judges to look at them and to interpret them in order for the law to be enacted. They're not documents that, for example, go without saying. You can't simply look at a constitution and have everybody agree on what it means. So interpretation is important, and that means in the British context that when UK courts, English courts, Scottish courts, courts in Northern Ireland look at cases, they go to and they rely on other sources or secondary sources because we don't have a constitution. So they can look at statute, which is created by Parliament. That's laws created by Parliament. They could look at common law, English common law, and common law is legal principles applied by courts, and these cover royal prerogative and statute. Now royal prerogative is quite a complex legal concept, but fundamentally it differs from statutes that are enacted by Parliament. UK courts can also go to convention, that is, rules of behaviour that are considered binding by and upon those who implement the Constitution. So convention, fundamentally that means the way that we do things around here, or the way we've always done things. It can also depend on authority, and that is written guidance and interpretation. So, for example, the classic case is Erskine May, 1844, who wrote a massive compendium of documents on guidance and interpretation for judges, but also judges will go back to what earlier cases have said and what earlier judges have ruled in earlier cases as well. What are the principal features of the UK Constitution? Now here we need to understand Constitution, of course, because it's not a written document. We need to understand Constitution as something that's constructed, something that's built. So the nature of the British state, the nature of the British way of doing things. In other words, Britain's political makeup. So what are the principal features of Britain's political makeup? They are parliamentary sovereignty. So Parliament is sovereign. It can't be overruled. The rule of law. And you'll find that in British foreign policy, particularly, people always refer back to one of the abiding principles of British foreign policy being an adherence to the rule of law, and this is how Britain attacks or criticises states that it disagrees with. It says, you don't operate according to the rule of law, we operate according to the rule of law. So it's not diktat, it's not dictatorial behaviour, It is fundamentally democratic. The unitary state. The unitary state is an organization that is over and above the wishes and the desires of individual leaders. So the Prime Minister, the Queen, government ministers and so on cannot override the state. The state is an operation that works somehow over and above the individuals who lead it. In political science and international relations terms, this of course means that states are people, and in legal terms, international legal terms, states are people too. Representative government. So we have a representative parliamentary democracy that's majoritarian. Flexibility. Constitutional arrangements rather than a written constitution itself in Britain. These constitutional arrangements are flexible and they can be interpreted. We have vertical and horizontal accountability. Vertical accountability in the form of general elections where governments are chosen and rejected, and horizontal accountability through auditing checks and balances within the constitutional setup. So Parliament is checked by an enormous number of committees, for example. Supporters of the constitutional setup can be critical of judges making law. So this is perhaps one of the problems with the Constitution that we can think of, or with the unwritten Constitution. What's the problem with judges making law and not having a codified legal framework set down in one document? And the traditional features of the so-called Constitution can all be challenged and are all challenged in the UK. So we can see this through devolution. Yeah, if the state is sovereign and Parliament is sovereign, why do we have devolution? Why was Britain part of the European Union? Did that flout or violate the principle of sovereignty? The Human Rights Act is another case. The European Court of Human Rights has jurisdiction, not jurisdiction, but it is superior to national law. And does this violate the principle of sovereignty? Let's look at the Westminster model. The so-called British Constitution, which, as we said, is a make-up or a construction made of various documents and practices and conventions, all comes together under the Westminster model. So, what are the features of the Westminster model? Government through but not by Parliament. So Parliament does not govern itself. The executive governs, but Parliament checks it and Parliament holds it to account. So in other words, any government that is done, or any government practices that occur, go through Parliament in order to be legitimised. Again, Bagehot, the 19th century commentator, says the efficient secret of the English Constitution, he says not the British Constitution, the English Constitution, the close union, the near complete fusion of the executive and legislature's powers. So there's some kind of mutual relationship between the executive and the legislature, between government and Parliament. That is, whichever party's in power and governs, and Parliament itself. they work together in tandem in some way. The executive's drawn from and constitutionally responsible to the legislature, so this kind of explains that in a way. The executive itself consists of ministers from the largest party, which is the governing party, and they come from Parliament itself. They sit in Parliament. They are MPs. So some things to remember. Parliament is sovereign. It may not bind its successor. So that means when Parliament changes, legislation, rules, the way that the country is governed will change or may change. The current government and the current Parliament may not compel the next Parliament to follow what it has done. We have a first past the post majoritarian electoral system, and that means that party which has the largest number of MPs becomes the government. We don't have proportional representation. This creates strong government and a strong so-called loyal opposition in theory. So things get done. Things get done because we have the first past the post system, and the opposition is not treasonous. The opposition is not working hand in hand with foreign powers. The opposition is loyal to the government and to the state, but it acts as a check to hold the government to account. So this is the Westminster model, and it explains or accounts for the way in which the British political system is constituted. If we look at the Garnett and Lynch model of majoritarian and consensual democracy, if we just look at the first row under the features majoritarian democracy and consensual democracy, we'll see the Constitution. Okay, so in a majoritarian democracy like Britain, it says the Constitution is flexible, amended by a straight majority. Again, we have this puzzle. We don't have a written constitution in the form of one document. So this must mean that all of those other documents and all of those other practices and all of those other customs are flexible and amended by a straight majority. So the constitutional setup of Britain is flexible and is being amended continually by the first past the post system with a straight majority. What are some of the critiques of the Westminster model? Well, according to Moran, 2011, we've got this problem of the continually contested nature of the Constitution. What is the British Constitution? It's constantly being challenged, held to account, interpreted, changed, moved around. So it's extremely flexible. There's nothing continuous about it. And so some people might say, well, how can there be any continuity in this? Where do we stand constitutionally in our relationship with the state in Britain? Devolution is an issue. If Parliament is sovereign, if states are sovereign, how do we account for the puzzle of devolution? What powers go to Scotland? What powers go to Northern Ireland? What powers go to Wales? Who has overall control? The House of Lords acts as a check on the House of Commons. So if Parliament is sovereign, which part of Parliament is sovereign? Is it the House of Commons that's sovereign, or is it the House of Lords that's sovereign? And if they're both sovereign, what if they disagree? The 2010 and the 2017 general elections created a situation in which there was a hung parliament, and the party which got the most votes, even though it didn't have an overall majority, was the Conservative Party. In both cases, they had to go to other political parties and have a coalition, invite them into the government so that they could create a majority. In 2010, they did that with the Liberal Democrats. So in fact, both parties tried to do it. The Labour Party and the Conservative Party both spoke to the Liberal Democrats, and of course the Liberal Democrats are kind of between Labour and Conservative, and eventually the Lib Dems went with the Conservatives and created a majority Conservative Lib Dem government. What does this say about liberalism? Is it more conservative? Is it more Labour? Is it more social democratic, or is it more liberal democratic? Problems with accountability. Northern Ireland, for example, Iraq, participation, elitism. Is the Westminster model simply bourgeois democracy? Is it what Marx and Engels called simply the board of directors for the capitalist setup? Is it just simply businessmen operating through Parliament? We've seen also a decline in classic models of mass participation, people being fed up of politicians, people believing that nothing that they say ever gets listened to, people not understanding how Parliament and government works because it's not taught in the state school system, in public schools. It's only taught in elite private schools, and this perpetuates the elite control of Parliament. Decline of deference and trust goes hand in hand with classic mass participation. Disaffection with the political system, and a movement to populism, and the idea that something needs to be done to, as you know who said in the United States, drain the swamp in Washington. And the financial crisis of 2008. That financial crisis had a massive influence on the way that ordinary people react and relate to government in the UK. Other models that we might look at, there's Rhodes' differentiated polity model and Marsh's asymmetric power model. These are some of the features. I'm not going to go through them in detail with you, but you might want to stop the video and just look at them, think about them, make a few notes, and consider in tandem with your core reading and through speaking to your friends, think about how these models work. So, in summary, there are elements of change and continuity in the new British system. So by the new British system, we mean the constitutional setup that we have post-1999, really, when Tony Blair reformed the House of Lords, and also post-devolution, where powers were devolved to the different nations within the UK, and also through reforms in local government. We've seen recent constitutional change and a changing in the British political system through this. And finally, we have the Westminster, but do we have a Westminster versus Whitehall model? And by that we mean, how is policy created? Is it created purely in Westminster through Parliament, the Cabinet, the Executive, in that way? Or is it in Whitehall, where the civil service is, in the government departments? And that is something that we'll move on to look at in the second session. So finally, there's some reading that you can look at. And thank you very much for listening.